We have a quorum. I call to order the meeting. Agenda item number 1, information papers issued since the last meeting. There is none. Now we move on to the next item, items for discussion at the next meeting. Would the relevant representative, well, they are already here. You have received LC paper number CB bracket 41023/2023 bracket 01 list of outstanding items for discussion. LC paper number CB bracket 41020/2023 bracket 1 list of follow-up actions. LC paper number CB bracket 41022/2023 bracket 01. It was a letter dated 13th of November 2023 on request for discussing the continuing powers of Attorney Bill from Hon LAM San-keung. LC paper number CB bracket 41022/2023 bracket 02 is the administration's response to the letter from Mr. Lam San-keung. The panel will, on the 18th of December 2023, Monday at 4:30 p.m., convene the next meeting to discuss the relevant items proposed by the administration. The first item is the latest development of the mechanism on reciprocal enforcement of judgments in civil and commercial matters between Hong Kong and the mainland. And the second item is improving the mechanism for mutual service of judicial documents in civil and commercial proceedings between the mainland and the Hong Kong. Any comments? If there is none, as mentioned, on the 13th of November 2023, Mr. Lam San-keung wrote to this panel requesting for a meeting on the continuing powers of the Attorney Bill, CPA Bill. I've already read out the LC paper number. There is a reply given by the Department of Justice, as mentioned. In the response letter, the Department of Justice said that the Labor and Welfare Bureau is the policy bureau of the CPA Bill, so it should be discussed by the relevant panel instead. And DOJ also suggests that the item on the CPA bill be removed from the list of outstanding items for discussion. That is the implementation of LRC report on enduring powers of attorney, personal care, continuing powers of attorney bill. I would like to invite Mr. Chung to see if he has anything to add. Thank you, Chairman. As mentioned, on the 24th of November 2023, we issued a letter of response detailing the situation. Perhaps I invite Ms. Fong to walk us through the background of the item. In August 2022, the Secretary for Justice has reported to this panel that the Labor and Welfare Bureau has taken up the role as the policy bureau for the CPA bill. In that meeting of the panel, Chairman mentioned this difficulty. It is difficult for this panel to follow up on issues that falls outside the scope of the Judiciary or the Department of Justice. The chairman referred the item to the relevant panel for follow-up. Response is pending. On the 17th of August, the Secretariat has issued a paper on this CPA bill to the Labor and Welfare Bureau for their response. The LWB made a response to the panel that the government is considering the way forward for this CPA bill. I would like to take this opportunity to explain why there is a change of policy bureau on this CPA bill. The Secretary for Justice was initially responsible for the public consultation for this CPA bill, and during public consultation, we received a large number of responses and replies. When we were looking into the implementation of the CPA bill, we discovered that the implementation involves government measures and allocation of resources as well as structural concerns. So we need the Policy Bureau to take up the bill. For example, on the guardianship board of statutory bodies, what are their roles under the CPA bill and the allocation of resources? These are the areas that should involve Labor and Welfare Bureau. So that explains why there is a change of Policy Bureau in taking up the bill. In the letter of Mr. Lam San-keung, he mentioned this advance decision on life-sustaining treatment bill. There is a significant connection between these bills. Should advance decision on life-sustaining treatment be involved in the CPA bill? What is the relationship and connection between these bills? We need a policy bureau to consider this matter holistically. So this is the background on why there is a change of policy bureau. Now I open the floor for questions. First, Mr. Lam San-keung. Because he wrote the letter, so I will allow 2 minutes for him to speak. Thank you, Chairman, for giving me this opportunity to respond to the proposed cancellation of the items. The meeting was convened in July 27th. I was not in Hong Kong, so I did not join the meeting. I didn't know that it was discussed there. According to the rules of procedures and other regulations, there is no mention of prohibiting LWB from joining our meeting. Despite or regardless of which policy bureau is responsible for the bill, it is very likely that the lawyers will be executing the bill. I don't see a conflict in inviting LWB to this panel. As mentioned by the Department of Justice, the advance decision on life-sustaining treatment bill will come to the Legislative Council next week. That is why I think that we should scrutinize this CPA bill as soon as possible. There is a Children Proceedings and Parental Responsibility bill, which was tabled in this panel's meeting in 2020 or 2017 to 2018, but it was rejected. The Family Committee of the Law Society and Bar Association both supported the bill because it's been implemented in the UK already. I've been following up on this matter, but the LWB did not respond to me. I have submitted an oral question for the council meeting next week. I hope that we can start scrutinizing the bill as soon as possible. Thank you. Any response from the Department of Justice? Thank you, Chairman. I fully understand what Mr. Lam said. In terms of this continuing powers of attorney bill, we're concerned about this. In the LRC report, we mentioned that this continuing powers of attorney bill focuses on personal care. During consultation, there were people who said that we should include more areas on top of personal care, including advanced decision on life-sustaining treatment. there was a comment in the consultation in 2017 or 18, and in 2019, the Health Bureau proposed or promulgated a consultation paper on advanced decision on life-sustaining treatment. It says that when there is conflict between the continuing powers of attorney bill and the advanced decision on life-sustaining treatment, we should accord priority to continuing powers of attorney bill. We consider this factor of personal care in the Law Reform Committee, and during the public consultation, 3 factors arose to affect our decision, including the personal care, the advanced decision, life-sustaining treatment, and the CPA. It involves public decision. So we don't just look at this matter from a legal perspective. When these 3 factors arise, we should take a holistic view. As mentioned by my colleague, there are a number of organizations involved, including Guardianship Board. Should we expand the scope of responsibility of the board? All these involve public resources and decision. That is why eventually we ask the LWB to take up the bill so that we can look at this matter from a holistic perspective. So that's the background. So it's not the case that we will not follow up on the matter after it's been transferred to the LWB. We support the bill and we want it to be implemented as soon as possible. When we are scrutinizing the bill in this panel or Bills Committee, I believe that my colleagues will give full support to it. But as for which panel will take up the bill or if it will be a joint panel, we respect the view of the Legislative Council. Thank you. Any other comments? If there is none, I would like to say a few words. Haven't heard what members and government has said. I think that this bill involves various government departments and policy areas. As mentioned, we should probably involve the Department of Justice and the Labor and Welfare Bureau and the Health Bureau on advanced decision on life-sustaining treatment. On this kind of cross-departmental or bureau's policy, it is not uncommon. Let me name an example. The legislation of national security law involves Security Bureau and the Mainland and Constitutional Affairs Bureau and the Department of Justice. I believe that there will be a Bureau taking the lead in scrutinizing the bill because the government is the most familiar with the allocation of resources and key area of policy involved in the bill. I understand the concern of Mr. Lam. I'm concerned about this bill as well. If we are to delete this item, I will write to the panel on welfare services to see if they can arrange for this item to be discussed as soon as possible. And when this bill goes to the panel on welfare services through Secretariat, I would ask the chairman to invite members of this panel to join that meeting for discussion. Other than Mr. Lam, is there anyone who objects to deleting this item from the outstanding item for discussion? Anyone in favor? Two members are in favor. So this item will be removed from the outstanding item for discussion. Next item. The Judiciary Administrator suggests removal of an item on subsidiary legislation relating to Stage 2 of Phase 1 of the Information Technology Strategy Plan, ITSP. The Judiciary Administrator said that they will submit information paper to this panel on subsidiary legislation related to Stage 2 of Phase 1 of the ITSP. The same practice was adopted in handling Stage 1 of Phase 1 of the subsidiary legislation. Any comments to the arrangement?
Well, if not, I will delete the item from the list of outstanding items for discussion. The next agenda item is technological advancement in the judicial process. Welcome, government representatives, as well as the two representatives from the two legal professional bodies. I believe members have received the papers, one being LC paper number CB brackets 41000/202302, paper provided by the Judiciary Administration. The next one being CB brackets 41000/2023 brackets 03, a background brief prepared by the Legislative Council Secretariat. Members who wish to speak, please press the request to speak button. I will first invite the Judiciary Administrator J.A. Ms. Esther Leung to brief members on the paper. Thank you, Chair. The paper is about the judiciary's efforts in making greater use of technology to enhance the efficiency of court operations. The use of technology must observe the principle of judicial fairness and impartiality. We have implemented a variety of technology initiatives, and these have been included in the paper. Here are a few highlights. 1. Integrated Court Case Management System, ICMS, is a major technological initiative of the judiciary. It allows users to flexibly make electronic payments within and outside of court hours, as well as submit documents. This system is implemented in 2 phases. In May and December of 2022, the ICMS has been implemented incrementally in the district court and magistrates courts, and these are now being used in personal injuries action, tax claim proceedings, civil action proceedings, and employees' compensation cases in the district court and summons cases in the magistrates courts. In the Stage 2, the ICMS will be rolled out to the Court of Final Appeal, the High Court, the summons courts of the magistrates courts, the small claims tribunal incrementally from 2024. As at end of October 2023, 350 court users, including 283 law firms, have registered for accounts under the ICMS. The judiciary has been implementing a series of promotion and facilitating measures to raise awareness of the ICMS. We have provided 20% concessions for the first 5 years. We have operated an ICMS help center to provide law firms and litigants with advice and assistance, conducting briefings and demonstration sessions. We have also filmed some promotional video clips. Starting from 2024, we will implement the deposit account for organization accounts, including law firms, to put in prepayments without the hassle of paying for each individual transactions. Starting from August of this year, starting with the High Court, we have been piloting a new mode of operation, including mandating the use of drop boxes for specified types of documents which do not require immediate processing or payment, and promoting the use of email communications for certain registry business. And starting from December of this year, we'll roll out such arrangement to DC registry. This operational mode can help induce a cultural change in the filing practice of the legal profession. From conventional over-the-counter services to contactless transactions and eventually to electronic transactions. The ultimate aim is to make the ICMS the primary litigation system. We will eventually have ICMS to be used mandatorily by all legally represented litigants. And before the end of this year, we will consult the legal profession and other stakeholders on the implementation arrangements. Remote hearings. We have been promoting the wider use of remote hearings for civil proceedings. We are currently working on a draft court's remote hearing bill to provide the court with the flexibility to order remote hearings. And in 2022, in June, we have launched a 3-month public consultation on the draft bill. We have consulted this panel in May 2023. In light of the extensive comments received, we are finalizing the bill, and we will, as soon as possible, introduce the bill into the Legislative Council for scrutiny. The Judiciary has also been looking into live broadcasting of selected judicial proceedings outside court premises. This is to maintain public confidence in our judicial system. We do understand that not all proceedings are suitable for live broadcasting. We are currently examining the guiding principles as well as the implementation practicalities of live casting. We hope that in early 2024, we will have a trial run on selected cases for this initiative. We will look into the technical and implementation arrangements. We will announce the details in due course. In relation to e-bundles, starting from 2017, in the Court of First Instance of the High Court and the Court of Appeal, we have started using e-bundles. We have extended the arrangement for hearings for suitable DC District Council civil cases since December 2020 and starting May 2022. For cases of the commercial list, the use of e-bundles has been made mandatory. And in July 2023, a new practice direction for the companies and bankruptcy list came into effect. We will see how best to encourage more usage of e-bundles at hearings in the near future. We can also talk about the e-appointment system. In the probate registry, the family court registry, and the lands tribunal registry, and in the apostille service office of the High Court registry, the appeals registry of the Clerk of Courts office, and the integrated mediation office, the e-appointment system has been rolled out in these registries. We are exploring to further extend the system to more registries. In relation to voice-to-text technologies, the Judiciary has been testing various voice recognition software products in the market from 2022. With a view to making use of this technology to facilitate judges and judicial officers (JJOs) in making notes. But a substantial amount of cases are conducted in Chinese in Hong Kong, which is why we have placed an emphasis on the accuracy of voice recognition in Cantonese. Over 10 months, we have been enhancing the accuracy, and we have been inviting JJOs to participate in the trial use of such software in actual cases. We have been improving the products, and we're looking into making use of the enhanced VTT software by the end of 2023 for JJO's real-time note-taking to facilitate judgment writing. And further model training will be carried out with a view to deploying the technology for preparing transcripts of court proceedings in the longer run to enhance the efficiency and effectiveness of court support services. For approximately 220 courtrooms of the judiciary, around 150, around 70% of them are equipped with user-friendly features and technological features, including video conferencing, multimedia presentation of evidence, e-bundles, and enhanced interpretation facilities, all integrated into a centrally controlled network. Also, display systems have been installed at court lobbies so that proceedings may be broadcast to interested parties who cannot be accommodated in the hearing court. The new district court building has had funding approved in May 2022. The works have commenced in July 2022. The works are ongoing and are expected to be completed at the end of 2026. And by the end of 2027, we plan to put in place a modern and robust IT and audiovisual infrastructure. We will also develop a new data center in the building to replace the existing aged data center at the High Court building as the central network hub and internet access point for the entire judiciary network. We also intend to upgrade the IT infrastructure systems in the West Kowloon Law Courts building's data center. This is to tie in with the implementation of the new DC building data center. We will consult this panel next year and will seek funding approval from the Finance Committee during the first quarter of 2024. The judiciary will make use of technology to continuously enhance the efficiency of court operations. Thank you. Right. We would like to invite Mr. Martin Wong of the Hong Kong Bar Association to speak. Please speak within a 5-minute time limit. Thank you. On behalf of the association, I have a couple of more points to make. We do appreciate the judiciary making use of innovative technologies to enhance court operations. This is the direction to take. And when members of the association have visited the mainland and overseas, they do see technologies being adopted to enhance court operations. And I think Hong Kong should keep abreast with the times on this issue. I can see that the judiciary has dedicated much effort. As we often say, Rome is not completed within one day. I think all stakeholders should work together on this initiative. This brings me to the next point. The association will work together with the judiciary on this initiative because we are users of the equipment of the judiciary. We are stakeholders, so we will encourage members of the association to know more about the initiatives and make use of such technologies so as to enhance efficiency. I would also like to respond to what the JA said. 1. In relation to remote hearings and live broadcasting. In fact, in last September, we have made a submission for the bill, and we do hope that our comments will be incorporated. And the Judiciary Administrator has also mentioned the use of e-bundles as well as some equipment that is being used for the presentation of evidence. Well, let me say this. The judiciary is working with the association to provide a course to our members in relation to the use of e-bundles as well as the latest technological equipment to make the best use of such technologies. And the training course, apart from having our members participate in person, it also allows for online participation. And this is exactly done with video conferencing facilities as mentioned by the JA. The new DC building will be completed in due course, and it was said that the technological infrastructure at the West Kowloon Law Courts building will be upgraded as well. We do appreciate such initiatives. We hope that such initiatives will enhance court operations. Thank you.
Thank you, Mr. Wong. Next, from the Law Society of Hong Kong, Mr. Christopher Yu. Yu, please complete your speech within 5 minutes. Thank you. Thank you, Chairman, Judiciary Administrator, and members. On behalf of the Law Society of Hong Kong, I would like to talk about the use of technology in the judiciary. We have a few points to make. First, the adoption of IT is the road to go, or the way to go. I hope that the JA will facilitate the adoption of technology in different levels of court. On our day-to-day litigation work. As we see in the mainland and other jurisdictions, they are adopting technology to shorten the court waiting time and enhance people's access to justice. Second, we agree on the Bar Association's point on training. We see that the judiciary has, upon implementation of the ICMS, provided training. The Law Society of Hong Kong works closely with the Judiciary and Department of Justice on testing out e-bundles, and we promote the ICMS to our members. We will continue to work with the Judiciary in the promotion and education of these technologies. IT is not something new, but when we adopt it in legal procedures, not everyone, including experienced lawyers, is familiar with the use of it, especially during emergency. If something goes wrong with the technology, we sometimes don't know how to handle it. So in terms of training and demonstration, we hope that the judiciary can provide high-level training, including ways to cope under emergency circumstances, so that the operation can be smoother. The Judiciary Administrator mentioned in the report live broadcasting. There is a timetable. So by early next year, there will be a trial run. We fully support the enhancement of transparency. This will boost public confidence in our judicial system. We look forward to the Judiciary Administration sharing with us the principles of adoption. We understand that some cases are not suitable to be broadcasted live. The trial one will start early next year, so we hope that we can engage in the relevant discussion as soon as possible. My final point. We have to promote the use of technology. This is inevitable. On top of making preparation for it, we have to manage expectations. When the Judiciary Administration is setting out the training and purposes and objectives of use of technology, can provide us with a timeline of implementation and a roadmap including milestones. The Law Society of Hong Kong and the members of the trade are happy to work with the Judiciary Administration in the promotion of technology. We hope that we can engage in your planning for any future projects. Thank you. Thank you, Mr. Yu. Now is the time for questions. First, Ms. Maggie Chan, 5 minutes, including question and answer. Thank you, Chairman. The agenda item of discussion today is the greater use of technology in the judiciary. I think that we should add 2 more words. That is the faster and greater use of technology in the judiciary. I know that the judiciary is working hard in this area, but we have to catch up. I would like to ask about paragraph 6 of the paper, usage of ICMS. As at 31st of October, a total of 350 court users, including 283 law firms, have registered for accounts under the ICMS. We have 11,516 solicitors in Hong Kong. We have 927 law firms in Hong Kong. So we have to work harder. I understand that you are working hard, but the numbers is not satisfactory. What is the reason? And how can you promote the wider use of the ICMS in the sector? Do you have any milestone KPI timetable? Second, I would like to ask about the remote hearings. In paragraph 10, it says that so far 1,700 remote hearings have been conducted, which includes video conferencing or phone hearings. So how many of these 1,700 remote hearings are video conferencing and how many are phone hearings? Judiciary Administrator, please. Thank you, Ms. Chan, for your question. Let me first answer your question on the usage of the ICMS and its progress. Since 2022, it was implemented in the district court, and in 2023, we will establish a timeline to mandate all law firms in using the ICMS. This is the plan that we established only this year. We are progressively enhancing the number of registrations. We have some training courses, as mentioned by the Bar Association. And in Wan Chai Court, we also hold seminars to teach lawyers on how to use the ICMS. But why is there not a surge in the registration? I believe that the sector needs time to get used to the new system. That is why I think that there should be different facilitation measures. For example, we are adopting a new mode of operation in the registry. Currently, About 70% of the document are placed in the drop box in the High Court instead of the counter. This change facilitates the sector in getting used to filing documents or submitting documents electronically. We think that this takes time, and we need legislation to mandate the sectors in making use of the system. At this stage, we will try to promote the use of the system. If there is anything that we can do to enhance the use of the system, we are happy to explore it. Second, I will talk about the remote hearings. The numbers, 1,700, include phone hearings and video conferencing. About 1,000 of remote hearings are phone hearings. For the rest, they are video conferencing. Thank you. Any follow-up questions? Yes, Chairman. Thank you. On how we can better promote ICMS, small and medium law firms account for about 90% of the total number of law firms in Hong Kong. If necessary, my association is happy to help. I think that we need an e-vouchers for technology. Please be brief, Judiciary Administrator. Thank you. For small and medium law firms, if Ms. Chen can gather them to come to the Legislative Council to learn how to use the ICMS, we are happy to provide a hands-on demonstration session. They don't need any mobile phones or laptops to do that. As long as they can connect their system to ICMS, they can file their documents. But I think that the sector needs time to get used to the system. Thank you. Next, Mr. Lam San-keung. Chairman, I'm happy to see that there are a number of measures in the paper that shows the judiciary's determination in promoting the use of technology. I have a suggestion and a question. In paragraph 9 of the paper, it says mandatory use of the ICMS. It says that the JA will consult the legal sector's views on the implementation approach and timetable. I think that we have to mandate the use of the ICMS as soon as possible. Because we are a common law jurisdictions, the prosecutions and the defense often have different views, and some parties will try to delay the proceedings. So one of the parties may not want to use ICMS. They want to delay the process as far as possible because they want to charge more. As this ICMS will expedite the process, some people may not want to use it. It's impossible for us to ask the law firms to adopt it voluntarily. So I think that we have to mandate it. I would also like to talk about paragraphs 14 and 15 on the e-appointments for specific court services. It says that only some registries are making use of e-appointments for litigants that are not legally represented. I received some comments saying that hopefully we can introduce e-appointments for court waiting so that they don't have to wait in person outside of the courts. Because this is a waste of time. We can make use of electronic means to, for example, seek consent on court orders. Sometimes after submission of reply to court order, the result does not come out within 3 months. I hope that the JA will provide us with the timetable on the e-appointments. Thank you.
多謝主席。
JA. Thank you. In relation to the mandatory use of ICMS, we will consult the sector at the end of this year in relation to the implementation arrangements, including the proposed legislative amendments. And some types of documents may not be suitable for digitalization. So we'll make exceptions and we'll consult the sector on the practical arrangements. So it's not whether we're not discussing whether it is to be made mandatory. And in relation to the timeline, we can definitely expedite that because early this year in the Chief Justice speech at the ceremonial legal year opening, it is said that we should do that, but it has been a couple of years since we have first proposed this ICMS. For e-booking, e-appointment system, we definitely want to roll it out to other levels of courts. In relation to the fixing of dates to have it digitalized, what do you think about that? Well, we actually have an option in high court registries to let people opt for email to fix court dates. We have implemented that for 2 to 3 months, but it seems that the sector is not used to such arrangement. They would often ask for dates to be fixed at registries, at the high court registry, so we will try to promote this model as much as possible. Any follow-up? None? Thank you. Vice Chairman, please. Deputy Chairman, please. In relation to the greater use of technology by the judiciary, I do appreciate the efforts of the judiciary in the past few years, and I can see that during the pandemic, technologies have been very useful in court operations, and it has enhanced efficiency. So we have been talking a lot about the ICMS. And the judiciary has issued guidelines or practical guide for users to facilitate their use of the system. But I do see the figures being relatively low. But is it the case that a single account works for all lawyers of the law firm? So that makes for the low figures. It's the same with chambers. Is it the same that one account is used for the entire chamber for all barristers in the chamber? So it's actually the case for my chamber as well. So I think it may not reflect the true figure of how many users there are. I can see that there are 24.2% of the total number of relevant new cases have been initiated under the ICMS. Do you have a target in the near future to have this rate increased? And will you encourage judges to ask the relevant parties to try to use the ICMS so as to promote this system? I believe it takes multiple stakeholders to promote the initiatives. It's not just the judiciary or the lawyers. I think judges or the judiciary JJOs should try to promote the use of the system as well. In relation to voice-to-text VTT technologies, we have followed up on this in previous panel meetings, and the accuracy used to be approximately 60%, and that is definitely not an ideal figure. It is said that it has gradually been improved to around 80%, and when will you roll out that for actual use? until what percentage will it be that you have it used for a wider context or in court transcription? Thank you. Thank you, Deputy Chairman. The first question was about the wider use of the RCMS. We will continue to promote the system and we will provide more training. But I consider it inappropriate to set a target right now because we have seen an increasing figure. The 24.2% figure is actually quite a significant increase from the original figure. So we will ask for people to register for accounts, and as this is just voluntary in nature at the moment, we do not want to set any hard targets. For legal practitioners, if they use other electronic means outside the ICMS, for example, the use of e-bundles, that will promote the wider digitalization direction that the judiciary is taking, and that is useful. In relation to voice-to-text technologies, in fact, in the market before, there wasn't an ideal product that we could use, so it took us a year to develop and test the model that we have, and we think that with an accuracy that we have right now that is approximately 80%, it can already be used by JJOs to take notes, but then 80% is not enough for actual court transcription because court records have to be very accurate. I won't say it has to be 100% accurate, but it definitely has to be more than 80%. I think we will need more time to see how it's going to work, but at least with 80% accuracy, it is already useful for judges for their note-taking. Thank you. Well, thank you. What I want to say is that the judiciary has been actively making use of technologies to enhance court operations, but this is what is only happening recently. Before, I did not really see much advancement in the adoption of technologies used by the judiciary. I believe that was before your stint in the judiciary, so I can see that the JA is quite determined in this regard. And as Mr. Lam said, I think the judiciary is quite dedicated. And as the representative of the Bar Association said, we really need to expedite the use of technologies in the judiciary, because compared to other places, for example, the United Kingdom and Singapore, according to a report published by a professional body, Hong Kong is really lagging behind in the adoption of technologies. Now, I want to ask this question. I believe other members have asked that, so I will not go into detail. It is said that there are 283 law firms that have registered for accounts under the ICMS, and as Maggie Chan said, there are 927 law firms. From my memory, there should be more than that. But I would agree that the ratio is relatively low. I do understand that the judiciary will make it mandatory to use the RCMS in future, but as you said, it would be another 3 to 5 years. So what I want to ask is, why is the sector unwilling to use the RCMS at the moment? Did you conduct any surveys, or if you're aware of this, can you elaborate on that? Why aren't they actively participating in the initiative? Well, thank you. From what we know, I think the sector needs time to get used to the arrangements of the system, and with the dissemination of information, they may not be aware of such system. So we have issued an appeal letter to the senior management of some law firms. We have also asked the president of the Law Society and 2 law firms to film some video clips to share with the trade the experience of using ICMS to promote the use of the ICMS by law firms of various scales. We hope that there will be a change. I think it responds to their wishes to not have the hassle of paying for each individual transactions. We have implemented a deposit account as an additional electronic payment option for the ICMS organization account holders. So before we make it mandatory to use the ICMS, if they have already started using the system, once we mandate the use, it will be a smoother transition. Thank you. Any other questions? If not, we'll move on to the next item. Let's invite the relevant government representatives to come inside the conference room. Well, I think we have 2 papers. Sorry, no, 1. It's LC paper number CB brackets 4/1000/2023 brackets 04, a paper provided by the administration. Welcome, Deputy Secretary for Justice Mr. Horace Chung and his team. For their attendance, I would also like to welcome representatives from the 2 legal professional bodies. I'll first have Mr. Horace Chung brief members on the paper provided by the administration. Thank you, Chair. I would like to thank the Chairman for arranging this meeting so that my colleagues and I can brief members on the development of and support for the Hong Kong legal profession in Hong Kong and within the Greater Bay Area. We would like to consult members' views on these initiatives. The DOJ has been fostering an environment conducive to the development of the legal profession and creating more opportunities for the legal sector to enhance its competitiveness. And the relevant initiatives have been set out in paragraphs 2 to 16 of the paper. I would like to report on 2 major initiatives in relation to the nurturing of talents as well as enhancing competitiveness. Under National 14th Five-Year Plan, Hong Kong has a positioning of a center for dispute resolution services and legal services in the Asia-Pacific region. Hong Kong is the only common law jurisdiction in the country in relation to foreign-related laws. Hong Kong has an important role to play. We want international bodies to establish presence in Hong Kong to maintain our competitive advantage. In order to consolidate such advantage as one of the new measures in the policy address, the DOJ will promote the establishment of the International Legal Talents Training Academy so that Hong Kong can play the role of a connector. We will help Hong Kong consolidate its position as such center, as well as help with the development of the country. Young lawyers are the future of the legal sector in Hong Kong. That's why the DOJ has been placing great importance in legal training, and all three universities that provide law degrees in Hong Kong rank in the top 100 in the world. And we have been providing advice and guidance in legal education and training. We'll continue to support the two legal professional bodies to review local legal education and training initiatives so as to nurture more legal talents.
亦都同多
Together with a number of international organizations, we have a secondment program which is supported and participated by a number of young lawyers. We have a number of exchange programs, training programs, and revise our Fiat Council list so that new lawyers have more chances to be trained. In terms of promotion of our competitiveness, we fully support the legal sector in order for the sector to understand more about our legal framework. The Department of Justice has been helping the sector in preparing for new frameworks. For example, on the mutual assistance between Hong Kong and mainland and the mutual recognition of various cases and decision, we have been working with a number of mainland authorities in better preparing our lawyers. On the amendment of 2022 arbitration ordinance in revising the revisions, we want Hong Kong to catch up with the world in the ORFSA, outcome-related fee structures for arbitration. In February 2022, we promulgated the funding options for arbitration and promulgated the guidance notes and checklists for ORFSA to support our sector's development in the GBA from paragraphs 17 to paragraphs 28. 38, we have already set that out, including the GBA lawyers examination. The Department of Justice has been helping our lawyers in integrating into the Greater Bay Area. Since the pilot scheme of the professional examination, we have held 3 examinations. About or more than 1,500 Hong Kong and Macau legal practitioners enrolled in the examination. Upon passing the examination, they can apply for a lawyer's license with the Department of Justice for Guangdong Province to practice in 9 mainland municipalities. About 360 lawyers have received such license. For application of practice and practice management and practice support measures, we have received 500 applications. The examination has extended 3 years, and the experience threshold has gone down from 5 years to 3 years in order for more young lawyers and barristers to practice in the Greater Bay Area to develop their career and contribute to the legal development of the Greater Bay Area. On allowing Hong Kong invested enterprises to adopt Hong Kong law and allowing Hong Kong invested enterprises to choose for arbitration to be seated in Hong Kong, these measures are related or mentioned in the policy address. Within 2024, we hope to adopt these measures from in Shanghai, Shenzhen, and the entire Greater Bay Area, so that more enterprises will adopt Hong Kong law as the applicable law in their civil and commercial contracts and choose Hong Kong as the seat of arbitration. We also support the prioritization of the use of Hong Kong legal and dispute resolution services to handle cross-boundary contract disputes. These measures will create more opportunities for the sector and allow global and mainland investors to use Hong Kong as a platform to enter the mainland market and to go global. Another measure related to the policy address is that we are establishing a standing interfacing platform with the Supreme People's Court as a high-level, regularized and institutionalized channel to promote legal research and practice in the Greater Bay Area, to turn differences into our edge. The Department of Justice will continue to work with the GBA task force, the legal department's joint conferences, and the working groups on legal matters to proactively promote the interfacing of talents and mechanisms to promote the development of legal profession in the Greater Bay Area. I hope that the members will support our policy measures, and I'm happy to listen to members' views. Lastly, I believe that members of the trade share this feeling. Our work is very busy, and we have to take care of our families. We don't have much time to care about our community. That is why in the upcoming District Council ordinary election, it's essential or very important to us. Through election, we can elect a district councillor who can help us solve community issues and enhance our quality of life so that we can spend more time in our families and work. So please remember to vote on the 10th of December to build a better community. Thank you. Thank you, Deputy Secretary, for your presentation and call. Now I will invite the Bar Association to speak. Or the Law Society of Hong Kong, Mr. Christopher Yu, to speak. Thank you. In terms of development and policies in the Greater Bay Area, I understand that the Department of Justice has done much. As always, the Law Society of Hong Kong will continue to provide support and comments to the Department of Justice's work, and we will encourage our members to participate in the development of our sector in the Greater Bay Area. I would also like to take this opportunity to share with you our work in the GBA. In terms of legal education and professional training, on Section 7A of the interns, we are establishing standards, including examinations, to create a free and open market so that capable students, including those that are familiar with the legal frameworks in the Greater Bay Area and Hong Kong, to participate. We have told or provided advice to the 3 schools of laws in Hong Kong to tell us our expectations of the law students. We will continue to communicate with these schools to provide high-level or high-quality training. In terms of the Greater Bay Area, the Law Society of Hong Kong have established a number of working groups. Over the past, including during the pandemic, we, together with the Bar Association of Hong Kong and the Department of Justice, participated and organized a series of forums on the Greater Bay Area with different special administrative regions and provinces, together with 35 different lawyers association, over 1,000 local and mainland legal practitioners participated in these forums. On young lawyers, as mentioned by the deputy secretaries, we have a mainland lawyer affiliation association. In March this year, we organized the first online roundtable. This was co-organized by the Guangdong Lawyers Association. We engaged a number of young lawyers in the forum to talk about mutual assistance, and we discussed authorities. On the 28th of November, we will organize another roundtable. The theme would be experience sharing on cross-boundary transactions under the 14th five-year plan of our country. In our social media, we will promote the roundtable. Over the past year, the Department of Justice has organized some 3 visits to the Greater Bay Area. In June this year, we participated in a Guangzhou, Nansha, Shenzhen delegation tour and visited legal sectors or companies in the mainland. And in September this year, we visited Huizhou together with the Department of Justice, and a few weeks ago, we visited Foshan and Shenzhen. The delegation tour this November was very special because it was led by young lawyers and the Deputy Secretary for Justice. The last 2 points that I would like to talk about is that the Greater Bay Area is a big family. We need to collaborate with different cities, panels, and associations. Together with we signed with 7 different cities in Greater Bay Area a Memorandum of Understanding. That is MOU. We have set up sharing mechanism under the MOU. Hopefully, we can radiate these measures by having this MOU. Lastly, I would like to make a conclusion with the aid of figures and numbers. Within this year, the Law Society organized 13 different meetings with Lawyers Association in the Greater Bay Area and the mainland. In Guangdong Province and the 6 cities of the Greater Bay Area, their Lawyers Association physically visited the Law Society of Hong Kong, and we organized and participated in 24 activities relating to Greater Bay Area and visited the Greater Bay Area 8 times. We expect that we will be organizing more visits to the Greater Bay Area and have more exchanges, and we will continue to facilitate exchange and collaboration with the Greater Bay Area and promote the advantage of having a lawyer's license in the mainland and the measures on allowing Hong Kong invested enterprises to adopt Hong Kong law and to promote the advantages brought about by our country's development. Thank you.
表許偉強。
Next, representative from the Hong Kong Bar Association, Mr. Richard Cole, Senior Counsel, please. The speaker's mic is not on. I would like to thank the department for giving us a very detailed paper and a very detailed introduction. I would like to make a couple of points. In fact, I want to report the direction of the association and the initiatives that the Bar Association is taking in relation to the GBA Legal Professional Education Examination. We would like to thank the central authorities for extending the scheme for another 3 years. I would also like to thank the State Council for lowering the experience threshold from 5 years or above to 3 years or above. I believe that will facilitate more younger barristers to take the examination and integrate into the development of the GBA. We do appreciate that. We are encouraging our young members to take the examination. In fact, last week we have held a seminar within the association. We have invited our members to take part in that. And I myself and a few members have taken the examination. We have briefed members on the association on the examination. We want them to not be pressured by the examination. We will have some intensive training courses, and in relation to the examination, we have also briefed members on that. We have invited a very experienced lawyer from the Guangdong province to tell members about how they after they have qualified, how they will operate and the points to note. For example, for the charging of fees, and if agreements have to be drawn up, what they have to consider, so that members will know what to do once they are actually operating in the GBA. So that's my first point. I would also like to report to members that, for example, in the paper it is said that the International Legal Talents Training Academy will be established. We do support that. And the Bar Association is more than willing to support the department in this. As you may know, the association for the past 10 years has been working with mainland institutions to provide some common law courses. We have been working with the Beijing University as well as, starting from this year, a university in Shanghai, to provide common law courses. We hope that we can continue to give such courses in future. We do understand that the country has been promoting training to be provided to mainland legal practitioners in relation to foreign-related law. And in fact, the president of the association and I have taken part in such course. And a few months ago, we went to Beijing and have given a lecture on international arbitration to some mainland legal counterparts. And in relation to the rules of international arbitration, for example, cross-examination, how to deal with evidence, and how to disclose documents, they are quite interested in that. But some lawyers on the mainland said they are not quite familiar with such work as they do not deal with such tasks in their daily work. So they do want the association to give more lectures in that regard. So that's what we've done in training. We have also been working with lawyers associations in the GBA. We have maintained close liaison with them. And in fact, we met with a representative from an association in the Guangdong province just a few weeks ago. They proposed that the association should provide short-term internships for them in Hong Kong law firms. We will consider that, and we will also invite mainland lawyers associations in facilitating arrangements for Hong Kong legal practitioners to work for a short period of time or have internships in mainland law firms as well. So that's it for my report today. Thank you. So for members who wish to speak, the order is as follows: Maggie Chan, Yung Ho-yen, Holden Chow, Professor Priscilla Leung, Dr. Junice Ho. So first, Ms. Maggie Chan. Thank you. 5 minutes, questions and answers included. In relation to the use of technologies, in fact, in the last item, we mentioned the use of ICMS, how we have to promote its use. And for small and medium-sized law firms, they do need more support for the adoption of technologies. For sole proprietors, they take up 47% of law firms in Hong Kong. So people are maybe too busy to vote in elections. In fact, they may be too busy to adopt technologies. For the adoption of technologies, we have technology vouchers. There are different schemes from different professional bodies and departments. So for small and medium-sized law firms, it's hard for them to apply to each body, and there is no dedicated website to disseminate information. So will the department consider providing one-stop information for small and medium-sized law firms? There are also many restrictions with technology vouchers. It apparently cannot take up over 50% of the project. So if existing technologies already meet our needs, shouldn't you encourage the use of such existing technologies to allow for a more efficient allocation of public money? I would like to thank the administration for taking my suggestion in relation to the establishment of the International Legal Talents Training Academy. I can see that there is also a standing interfacing platform with the courts on the mainland. So apart from the Department of Justice working on that, would you consider involving the officers or people from the judiciary in this initiative. Deputy Secretary, please. Thank you. I do appreciate the members' support, and every time you see me, I would be talking about encouraging the use of technologies. So for small and medium-sized law firms, we do understand they have difficulties, and we are trying to provide support to them. And during the pandemic, we have rolled out a fund to encourage the trade to adopt technologies. And as the members said, small and medium-sized law firms do not have much time to adopt technologies, but I think we shouldn't think of adopting technologies as a burden, because when technologies are used correctly, it can enhance efficiency and save costs. In the medium and long term, this is beneficial to the development of the trade. So we really have to change the way that we think to resolve this issue. And to promote the use of technologies in the trade, it's not just about small and medium-sized law firms. It's about the judiciary. It's also about the trade in general. It involves all stakeholders to promote this initiative, and we'll continue to do work in this regard. Next, it would be my turn to speak. Well, Chair, excuse me. Is it possible for them to respond to my second question? A brief response, please. I'll have Ms. Peggy Au Young, Principal Government Counsel, to answer that. With the establishment of the standing interfacing platform, we want to promote interfacing in the Greater Bay Area. We think that the platform would involve the mutual legal assistance arrangements in civil and commercial cases. And we do note that such cases are handled at various levels of courts on the mainland. With proper interfacing, it will be greatly beneficial to the legal sector in both places. Based on the actual circumstances and needs, we will invite the central legal authorities to invite the relevant bodies to participate in the initiative. We will continue to liaise with the Supreme People's Court on that. We have details. We will report them in due course. Chair, excuse me, I'm asking, will they involve the judiciary of Hong Kong in the initiative? Well, similarly, we will involve the various stakeholders to provide feedback on the platform. As I said earlier, for some mutual legal assistance cases, we have been liaising with the judiciary on the arrangements, because the actual arrangements are implemented by the judiciary. So whether it's experience sharing or the implementation, we have been working with the judiciary in that, and we believe the platform will be greatly beneficial in this regard. Next, it would be my turn to speak. I do appreciate the department's efforts in the past 2 years, especially with leading delegations to visits, and I myself have visited Chengdu and Beijing and Hainan with the department. I think people have a good impression of us. Whether it's barristers and solicitors, we all want better connectivity. Hainan is not part of the Greater Bay Area, so we do want to not limit ourselves to the Greater Bay Area. So for the Greater Bay Area, if we have knowledge about laws on the mainland and in Hong Kong, can we go outside of the Greater Bay Area? I believe we can be good GBA lawyers, but if we want to create the brand of one country, two systems, we need to provide our services outside of the Greater Bay Area so that our friends in the mainland or people from overseas will know that Hong Kong lawyers are indeed talents or elites in the legal field. So will you provide opportunities for GBA lawyers to go outside of the Greater Bay Area? Thank you.
Thank you for your support of our work. And in our work and in the delegation visits that we led. I would also like to thank the two legal bodies. They support our work in full. They always work with us in telling good stories of Hong Kong in the mainland and overseas. Deputy Chair asked how we can brand ourselves better in the Greater Bay Area and on the international stage. In allowing Hong Kong invested enterprises to adopt Hong Kong law and to choose for arbitration to be seated in Hong Kong, these are the initiatives that we promote in the mainland that are adopted in Shanghai and other pilot legal zones. If we want to further expand it to the Greater Bay Area, that will be a great step forward because we have 90 million people in the Greater Bay Area, and in Hong Kong we only have 7 million people. When we went to Hainan, I remember when we visited Hainan, members of the sector talked about the advantages of allowing Hong Kong invested enterprises to adopt Hong Kong law and to choose for arbitration to be seated in Hong Kong. The mainland officials who sat next to me asked me how if they can adopt Hong Kong law in their jurisdictions. So after the delegation visit last time, we are already talking to Hainan authorities on adopting Hong Kong law in Hainan. Hopefully we can adopt this initiative of allowing Hong Kong invested enterprises to adopt Hong Kong law and to choose for arbitration to be seated in Hong Kong in cities other than the Greater Bay Area. All along, Hong Kong lawyers can sit for lawyers' examination in the mainland. That is a very difficult examination. I sometimes came across lawyers who are practicing in the mainland. We want to expand the GBA legal professional examination to cities other than the Greater Bay Area. Thank you. Next, Mr. Holden Chow. Thank you, Chair. Let me declare interest. I have passed the Greater Bay Area legal professional examination. I welcome the initiative. And I understand that the central authorities and the Department of Justice extending the pilot scheme or lowering the experience threshold from 5 years to 3 years. I believe that a lot of young lawyers in Hong Kong will benefit because a lot of young lawyers want to take the examination, but they did not have 5 years of post-qualification experience. Hopefully, they will be encouraged to sit for this GBA legal professional examination. That's my first point. Second, on the promotion of allowing Hong Kong invested enterprises to adopt Hong Kong law in the Greater Bay Area, I support that in full because that will create more opportunities for the sector. Because we have, well, of course we have to take a step at a time, but while we are conducting this pilot scheme, will there be ancillary facilities for Hong Kong lawyers when they are adopting Hong Kong law? Do we have ways to cope with issues? Some zones welcome Hong Kong lawyers in opening up office in their cities. that allows people to know that this initiative of allowing Hong Kong invested enterprises to adopt Hong Kong law is already implemented in that particular city. Sometimes that's how things are. Of course, it's difficult. It's easy for the mainland businessmen to come to Hong Kong, but if we have people know that allow this initiative of allowing Hong Kong invested enterprises to adopt Hong Kong law is established in certain cities, they will know that such services are provided in their own cities. Do we have such arrangement? Thank you. Deputy Secretary for Justice, please. Thank you. Congratulations on obtaining the lawyer's license. There are a number of electrical members who have obtained the qualifications to contribute and create impetus for the legal development in the Greater Bay Area. On the 9-city situation, we have some arrangement. Perhaps I'd invite Ms. Peggy Aoyang to elaborate on that. Thank you, Mr. Chow, for his question. That is correct. The Department of Justice has been working with the Department of Justice of the Guangdong Province to assist lawyers who have obtained the lawyer's license, including solicitors and barristers, in establishing their offices in the Greater Bay Area. And the Department of Justice of the Guangdong Province work with us. I would like to thank them. They have a procedural guide stipulating the application procedures, scope of business, supervision and management, and so on. They have a procedural guide with a compilation of frequently asked questions. That's the level of Department of Justice. On the level of Lawyers Association of the Guangdong Province, they keep in close communication with the 9 Lawyers Association in the 9 cities of the Greater Bay Area. They have a number of measures, including explaining the guidance of practice in the Greater Bay Area and encouraging lawyers to open office in their cities. They have a number of interfacing meetings as well. A lot of members of the sector attended these seminars. They also have practice guidelines and interfacing services. I would like to talk about Shenzhen because a lot of lawyers in the Greater Bay Area established their office in Shenzhen. They have practice centers to cater to the needs of the Hong Kong and Macau lawyers. It makes two-way referrals, communication, and matching services easy. With the support of the Supreme People's Court, we will have a practice training that's on practice or practical interfacing. Hopefully, lawyers who have passed the Greater Bay Area Legal Professional Examination will join the training course. When we have more information, we will promulgate them in due course. Next, Professor Priscilla Leung, please. Thank you. Over the past 30 years, I've been pushing for a number of initiatives, and they are implementing progressively. On reciprocal enforcement of judgments in civil and commercial matters, that's what I mentioned in my doctoral thesis. The Hong Kong legal sector did not want to see it happen then, and I'm happy to see that it's been implemented. In Guangzhou, I participated in an expert panel on bankruptcy law. The reciprocal enforcement of judgments do not cover bankruptcy law. They want to have a breakthrough. It's easy for Guangdong to interface with Hong Kong. We need matching services of business. For merger and association, it involves different jurisdictions. I think that Hong Kong and mainland lawyers can work together. I took the GBA legal professional examination as well. I studied it for 2 months. Although I've been teaching China law for over 10 years, I actually studied the mainland law first before I studied common law. By taking the examination, I am supporting the trend. In terms of matching services, I think that the young lawyers, including the solicitors and barristers, want to figure out what their expertise is. A few generations of the legal practitioners know each other. We hope that the lawyers in Hong Kong and the mainland can work together to make a bigger pie for everyone. At first, we had doubts about the mainland because we don't want to create an even more fierce competition, and they were wary of us as well because they don't want to create a fiercer competition there either. It's best for us to go for arbitration in the courts in the mainland. It's hard for us to compete in criminal courts in the mainland because they don't trust us. But if we work on international legal matters, that's a different matter because everyone benefits. So I proposed a initiative in branding Hong Kong's legal edge in the last MPC meeting. And my initiative was received very positively. Lastly, on the International Legal Talents Training Academy, we need to have an international perspective. We should not limit ourselves to a small circle. We have to invite recognized international experts to teach the courses. We have good lawyers in Hong Kong, and we are born with international perspective because we are bilingual. But the coaches and teachers have to be convincing, and the trainers of the International Legal Talent Training Academy have to be experienced and recognized. We need to have qualified talents because the National Arbitration Center is located in Hong Kong. The international law of our country is ahead of Hong Kong, as you know. So I hope that we will be serious about engaging qualified talents in teaching the courses. We need to have the recognition of our country as well because they are familiar with international law in WTO and in international treaties. So that's my comment. I am happy to support and provide views to the government in how our young lawyers can participate in the GBA market. Next, Mr. Junius Ho. Thank you, Chair. I read the paper. There are a number of working groups, panels, committees. In the Greater Bay Area, we have a number of initiatives and programs. Deputy Secretary, you are an elite from our sector. There are 3 groups of lawyers who have taken the legal exam. Among the 15,000 students who took the exam, the passing rate should be about 2/3. In paragraph 27, it says that we should make use of the communication channels with the mainland authorities. There are a number of communication channels. We have signed a number of memorandums with Guangzhou, Shenzhen, Guangdong on arbitrations, mediation. When we are signing these records of meetings with the cities and provinces, they have their own considerations. In Guangzhou, they have a Greater Bay Area practicing lawyer panel, and they engaged me as one of the members. So it seems that there are panels and committees here and there. And I don't see any coordination mechanism between different panels and committees. It seems that I have to repeat myself in different meetings. I am very hardworking. I've been attending meetings here and there, and I attended a number of courts. And I do have experience in the mainland courts. Although I've been a lawyer in Hong Kong for 30 years, I have to start from scratch when I practice in the mainland. There are some good things about the mainland system, and there are some room for improvement as well. I think that the Deputy Secretary can piece the 1,500 jigsaw puzzles together so that we can work in a more focused manner. Otherwise, I will have to repeat myself time and again in different meetings. So in paragraph 27, it says that there is a working group in the Greater Bay Area on arbitration and mediation. And it also mentions a joint conference. And you mentioned practice and management. Why can't you combine all these together? Now we have signed this memorandum with the Guangdong, and what about Guangzhou? I think we need a delegation chart. Can you provide us with a plan or chart stipulating the measures signed with different levels of department? Otherwise, we don't have a conclusion on our direction. So which measure or initiative should override others? I attended so many meetings, and I could be wasting my time.
Let's have a brief response by the Deputy Secretary. I do agree with what Dr. Junius Ho said. Whether it's members of the trade or members of the public, with the information relating to the Greater Bay Area or the legal system in the GBA, I have similar observations myself. And starting early this year, in the GBA task force, we've been asking to set up a one-stop information platform in relation to GBA to facilitate members of the trade as well as members of the public. We also hope that in the next year we will have this standing interfacing platform. It would be a high-level mechanism between the Department of Justice and the Supreme People's Court to resolve issues. As the members said, there are various levels of courts on the mainland. Well, I would say that with the interfacing, it has to go with various levels of courts on the mainland. So while we do have a high-level mechanism, we do want the arrangements implemented in lower courts. So what I want to say is that when we promote such initiatives, the department has to liaise with various levels of courts on the mainland. For members of the trade or electrical members, if you have any questions, just come to us. We will deal with such questions. We hope to help members of the trade and electrical members. Well, we do want the Department of Justice in taking the lead for that. Next, Mr. Lam San-keung, the last one to speak. Thank you. Well, most parts of the paper are in relation to the support measures in arbitration and mediation. So I can see that the department is indeed trying to consolidate Hong Kong's position as a center for dispute resolution services and legal services. We have 20,000 registered practitioners, and we have practicing practitioners amounting to 10,000 odd. Of course, we do want harmonious relationship to promote the healthy development of the trade. In fact, Hong Kong lawyers play a key role in the development of businesses. For example, for financial companies, they need specific expertise in financial law. For maritime companies, they need dedicated expertise in maritime law. And for advanced technologies, family offices or companies dealing in such business, they all need their dedicated expertise. So we really have to make sure our services can help them to create a brand for Hong Kong. So I've read the paper and I've heard feedback from the trade. I believe the administration did not provide adequate support for the trade. Hong Kong government has often said that they value rule of law, but they do not provide training in that regard. So with the training of international legal talents, will you provide training specific to foreign-related law, and will you also provide knowledge in specific disciplines, the ones that I mentioned earlier? And I want to ask, for the office for the establishment of the academy, who will you appoint in the office to make sure appropriate training is provided, in the sense that this training should meet the needs of the other trades of Hong Kong? Thank you. That's it for my questions, Deputy Chairman. Thank you. Under the National 14th Five-Year Plan, an important task of the department is to consolidate Hong Kong's positioning as a center for dispute resolution services in the Asia-Pacific region. And as Mr. Lam said, we do agree with the points being made by Mr. Lam. And I think, as Mr. Lam said, the development of legal services ties in with the development of other businesses. So we are not walking alone. We are walking along with the other trades. So for the 7 other centers, they will need the support of legal services. So legal services is special in that regard. And early November, the department has held a Hong Kong Legal Week 2023. You can see something special about this year. There is a particular session on how Hong Kong's legal expertise can help support the 7 other centers of Hong Kong. So we have invited experts and leaders from various sectors to have exchanges with us. That is exactly how we are going to achieve a synergistic effect between the legal sector and the other sectors. That's what we want to promote in this year's Hong Kong Legal Week. And we will continue to work on this. And we have an office, as Mr. Lam said, for the establishment of the International Legal Talents Training Academy. It is to make plans for the establishment of the academy, as the name suggests. But as you said, it does not involve only us. We will involve international experts, as I said earlier. We will also have an expert committee for the establishment of the committee for the academy. So we will involve the academia or experts from the sector and other sectors to design the curriculum and to facilitate the establishment of the academy. And we are making preparations for that. We will need the support of electrical members and members of the trade, as well as members from other sectors to help us with that. Once we have any progress, we will report that to members of electrical. I don't see any other members having questions to ask. The next agenda item is AOB. There is no other business. This is the end of the meeting. Thank you.